Yes, Mr. Mwangi.
Yes, my lord, I said I'm going to start on an unfortunate note, in that I have to call out a senior counsel for a hypothetical positioning. And I am reading the third respondent's submissions, paragraph 67 and 68. Third respondent says that the third respondent submits that the failure to tender a withdrawal as contemplated under Regulation 52 of the Election General Regulations, the fourth respondent, presidential candidate, did not legally withdraw from the 26th October 2017 presidential elections. And in paragraph 68, third respondent counsel proceeds to say that the third respondent is not aware of any Form 24A that was delivered to the second respondent by Raila Odinga at any time. No evidence has been produced by the petitioner of Raila Odinga's withdrawal from the fresh elections, either within the time allowed by law or at all. But he has just now come before you and based an entire application on the basis that Raila Odinga boycotted the elections. So they're blowing hot and cold on one issue, when now it serves to support the application for striking out. Their position is that there was a boycott. When it serves to give credibility to the election of 26th, then the position becomes that Raila Odinga was a candidate. But notwithstanding, my lord, I think the question that should be before this court is not, as asked by my learned senior, what the role of the fourth respondent is, but whether the fourth respondent is a necessary party to these proceedings. And again, I will start again on the third respondent's own submission, because throughout the submissions of the third respondent, they have made various allegations against the fourth respondent. I will just highlight the paragraphs and the pages in which they are. Paragraph 9, paragraph 12, that is on page 2 of the submissions. Paragraph 39, and what I've read, paragraph 67, paragraph 68, paragraph 69, paragraph 111, paragraph 112, and paragraph 118, and lastly, paragraph 139. All of them raising issue with the conduct of the fourth respondent in the matters relating to this petition. I will also, in the petition itself, wish to refer you to various paragraphs in which matters relating to the fourth respondent have been raised. There is paragraph 18, subparagraph G, H, I, and O of the petition. Paragraph 79, paragraph 81, paragraph 84, paragraph 88, and paragraph 93R. The question would be, in those circumstances, what was the appropriate response of the fourth respondent once filed in a petition in which its conduct is the basis of some of the prayers that are being sought by this court. And our response was to respond to the petition by placing before the court matters which we think explain the situation in which we found ourselves in. And being a legal proceeding, you can only respond by placing before the court the law and the evidence. Though it is suggested that all we needed to do is make an acclaim. We don't agree with everything entirely that with many things on which the petition itself is based, and on many allegations that they have made, which we shall, at the hearing, point out. But, my Lord, it cannot be suggested that in the light of allegations that are made against the fourth respondent, both in the petition and in the response of the third respondent, that we were not supposed to mention any matter which we thought would be central before this court in reaching a decision. My Lord, to go into an argument now on what would turn out by our participation would literally mean that we have to present our case to you now and to prove to you that our appearance before you is proper and that our submissions before you are proper. I believe the right place to do that is during the hearing of the petition. As we have been able to show, we do have, and both the petitioner and the third respondent themselves have laid the basis for us to be before you and for us to come and place matters before you. Another issue that is also hypocritical of the third respondent is that they say that by the time we filed the response, we locked them out from replying because the time for making responses was over. But that applies to what they say in the submissions, because I don't know at which point they also anticipated that the fourth respondent is going to answer to those things they have said in the submissions. So the same accusation they are making of the fourth respondent is the one they themselves have already committed. Because if they thought that it was right that somebody should have a chance to say something after the last documents have been filed, they would have avoided making the allegations they make against the fourth respondent. They are not even offering to withdraw those allegations that they have made and the accusations that they have made. For that reason, my Lord, this application just to the fourth respondent for a petition to go into hearing, its conduct, and the conduct of its members and officials to be discussed, and at no time during that entire hearing are they given a chance to place before the court what their position in that matter is. That is all, my Lord.
Thank you, Mr. Mwangi. Mr. Mwangi, address rule 11.2.
My Lord, in respect of the documents.
What does it mean? What does it say in 11.2?
Yes, my Lord, our position is peculiar. When we begin from the point that we are brought before this court and we have been sued and made respondents in these proceedings. If our question and our answer to this petition is not a straight yes or no, and in our case gets complicated by the fact that many allegations are made against us, we would say yes. If we were to merely support the petition, we would say yes, we do support the petition. But to do so without explaining our position on many of the matters that have been said would literally mean that we are accepting the petition and agreeing to everything that has been said, including the various accusations that have been made against the coalition and its officers and members.